Okay, we've probably held off long enough. Hopefully people will keep on trickling in, but I don't want to delay this too much so that we don't carve too much into the time that we have allocated. Hello, everybody. Welcome to what I hope to be an interesting panel on a case that was decided this past October by a judge in the Northern District of Texas, in which the Indian Child Welfare Act, a statute that's been around since the 1970s, was struck down on equal protection grounds. This is a fundamental case for a number of reasons, not just for ICWA's purposes, but also for Indian law generally, because the Supreme Court has repeatedly over the decades applied a political relations test in the Morton v. Man test to analyze statutes passed by Congress and not the equal protection test that is a higher standard, which the district court applied in the Brackeen case. And so the ramifications of this case and decision, if upheld on appeal, are pretty significant for Indian country as a whole, and it's a case of great importance and interest to practitioners who work in this area. We have today a distinguished panel who are all involved in the case. I am just going to say a few words about each one of them, and then if they want to use any portion of their allotted time to amplify a little bit their relationship to the case, I would encourage you to do that. If you don't want to, that's fine as well. Tim Sandefur and Rob Dunn, both on the end over there, both represent the parties in the case that are seeking to overturn ICWA. Tim Sandefur is the Vice President of Litigation at the Goldwater Institute. He's litigated a number of cases that involve economic liberty, private property, and individual rights. He's the author of numerous books and law review articles. In the materials that are available is one of his most recent, I believe, law review articles, which is specific on this topic, so I would encourage you to read that. Rob Dunn is a senior litigation associate at Gibson, Dunn and Crutcher. He practices in a number of their practice areas, among which is the Supreme Court and appellate practice area. He's been involved in a number of Supreme Court cases on religious freedom-related issues in particular. He clerked for Supreme Court Justice Clarence Thomas and Ninth Circuit Judge O'Scanlan. Professor Fletcher and Keith Harper, who are on the closest to me, both are also involved in the Brackeen case, representing tribal interest in the case. Professor Fletcher is a professor of law at Michigan State University College of Law. He's also the director of the Indigenous Law and Policy Center at the school. He is involved in a number of tribal courts around the country. He's the chief judge for the Porch Creek Band Supreme Court, and he's also an appellate court judge on other tribal appellate courts. He is a prolific writer and also is the person behind the Turtle Talk blog, which many folks in Indian country rely on for updated information on Indian law issues in the field. Ambassador Harper, I've known Keith for probably 20 years. First met him when he worked for NARF and was responsible at NARF for litigating the Cabell case. Since then, he's gone on. He was an ambassador during the Obama administration. He was the U.S. ambassador in the permanent United Nations Human Rights Commission in Geneva. He's since come back and is a partner at Kilpatrick Townsend law firm, and has a very large footprint in all kinds of areas in Indian law. So the way I'm going to try to run this panel is to try to be balanced. As you probably all who are aware of the case and familiar with the case know, it's a case that has some elements that get people's passions engaged. It's also a very interesting case from a policy and law standpoint and historical standpoint, so there's really a lot to it. What I'm going to do is give each speaker 15 minutes to present their materials, and then we'll have a question and answer period at the end, so I'll hold all questions until the end. That will give us hopefully about 20 minutes for questions. We're going to start with Tim, and then we're going to go to Matt, Professor Fletcher, and then Rob will be third, and then Keith is going to be the closer on the panel. So, gentlemen, you can either stay seated if you'd like, or you're welcome to come up to the podium, whatever your preference is fine with me. So,
I think I'll just sit here and not have to wrestle my way around.
Okay.
Thanks everybody for joining us. Let me very quickly, as quickly as I can, summarize what the Indian Child Welfare Act, or ICWA, does, and then talk a little bit about part of the Brackeen case, that is the equal protection part of the case, and leaving the federalism side of the case, which is very fascinating to Mr. Dunn. The Indian Child Welfare Act was passed in 1978. I suspect that that's the only thing anybody on this panel will agree with, or that everybody will agree with. What it does is it sets a separate set of rules for that apply to child protection, foster care, and adoption cases that involve children who are defined by the statute as Indian children. And the definition of Indian child in the statute is really one of the central controversies in the Brackeen case. Now this, it defines an Indian child as a child who is either a tribal member or who is eligible for membership in a tribe and also has a biological parent who is a tribal member. It's that last category that's particularly the problem, because as the Brackeen court itself noted, that means that ICWA applies to children who may never become tribal members, children who have no cultural, religious, linguistic, etc. relationship to a tribe, but whose eligibility for tribal membership is based exclusively on biological considerations. And that's what raises this question of the applicability of the Morton Precedent. The Morton Precedent said that the federal government can distinguish between tribal members, non-tribal members, and that that's a political affiliation, not a racial category, and therefore subject to rational basis scrutiny instead of the strict scrutiny that applies to race-based categorizations. But the court said in a footnote, we are not dealing with a law here that categorizes people differently based on their Indian status. And those of us on this side of the panel contend that ICWA does do that, crosses that line, and therefore that Morton is not applicable. But it's important also to keep this in mind, because a lot of the inaccurate media reports that you've heard about this lawsuit have said that the decision in Brackeen in some way threatens tribal interests aside from child welfare matters, such as tribal casinos and tribal land and so forth, and it simply doesn't, because ICWA is totally unique in federal law in defining Indian child in terms of biology alone. The other statutes, the Indian Gaming Regulatory Act and so forth, those things specify either tribal membership or tribally owned land and that sort of thing, and are not triggered by biology. Now, what ICWA does is it imposes it's a complicated statute, and we don't have time to go over all of it here, but I'll just cover a few of the things. It imposes race-based placement preferences on children who are in foster care or are subject to adoption. That is to say, children who qualify as Indian under the statute must be placed in foster care when they are placed in foster care in accordance with certain specified race-based conditions, including that they must be placed with an Indian foster home regardless of tribe. And likewise, with an adoption case, a child who qualifies as an Indian child under the statute must be placed with an Indian family, regardless of tribe, before that child can be placed with a white, black, Asian, Hispanic, etc. family. And that's important, that it's not based on tribal affiliation there. It's based on Indian status generally. Our contention is that the idea of generic Indianness is itself not only a racial categorization, but is a racist construct in itself. ICWA also imposes restrictions, different levels of evidentiary requirements on matters such as the termination of parental rights, which is often a step necessary prior to adoption. To terminate the parental rights of a child of any other race, you follow state law, and state law, in accordance with the mandate of the U.S. Supreme Court, is that termination of parental rights can only occur upon clear and convincing evidence that the factors required for termination exist. Clear and convincing evidence was the standard that the Supreme Court required in a case called Sandefur, because it said, if you make termination of parental rights too easy, as you would with something like a preponderance of the evidence standard, well, that would be dangerous to families. If you make the standard of evidence too high, as with beyond a reasonable doubt, well, that would be dangerous to children when the state needs to terminate the parental rights of abusive families in order to protect those children. So they said, therefore, the limit should be clear and convincing evidence, which is right in the middle. And that is the law in all the states, but it's not the law under ICWA. ICWA requires not only beyond a reasonable doubt, but also beyond a reasonable doubt on the testimony of expert witnesses, which is an extremely high standard, virtually unmeetable standard in most cases probably, for termination of parental rights. And so you have cases such as a case that we were working on some time ago in Arizona, representing a tribal mother. She was a member of the Tohono O'odham tribe, but she lived in Tucson off reservation. She had an abusive ex-spouse. She wanted to terminate his parental rights after they had broken up. She wanted to terminate his parental rights so that she could have her new husband adopt her child as his own. Now, if she had been a non-Indian person in Arizona, then the standard of evidence would have been clear and convincing evidence. And if she had lived on reservation, tribal law would have applied, and Tohono O'odham law in this regard is identical to Arizona state law. So again, clear and convincing evidence would have applied. But because the child qualifies based on his genetics as a tribal member but living off reservation, ICWA applied, and that meant that she would be required to prove beyond a reasonable doubt on the testimony of expert witnesses that the standards for termination existed, which of course was beyond her means. Among other things, she couldn't afford expert witnesses. Or you have cases such as in re TAW, decided by the Washington State Supreme Court 3 years ago now, in which a tribal member mother wanted to terminate the parental rights of her ex-spouse so that her new husband could adopt her child. This is very frequently the fact circumstances, these step-parent adoption cases. And the ex-spouse is able to invoke ICWA to block that from occurring. Amazingly, in the TAW case, the ex-spouse who invoked ICWA was non-Indian. He was a white man, not a tribal member or eligible for membership or anything like that. And he was allowed to invoke ICWA to block the tribal member mother from allowing her new husband, himself a tribal member, to adopt the child. So you have ICWA, which is supposed to be preventing the breakup of Indian families, actually preventing the formation of Indian families and interfering with the choices of Indian mothers in doing what's best for their children, a right that the U.S. Supreme Court has called fundamental. Another issue that has only recently been addressed in one ICWA case that I'm aware of so far, but I think is an area that needs a lot more attention, and that is the question of personal jurisdiction of tribal courts. ICWA gives tribal courts authority to decide cases involving, quote, Indian children. Now, of course, if it's a case arising on tribal land, obviously that's subject to tribal court jurisdiction. Nobody has any problem with that. But when you're talking about cases that occur off tribal land that would, if the child were of any other ethnicity, be decided by state court, ICWA comes in and says if the child qualifies as an Indian child, then the case should be sent to tribal court. And we've had cases where tribal courts try to assert authority, jurisdiction to decide these cases, even though the child has no cultural, religious, linguistic, or other kind of affiliation to the tribe except biology. And so what you then have in those cases is an assertion of race-based jurisdiction by tribal courts, which is quite astonishing. In a case that we're currently litigating that originates in Ohio, a tribe in Arizona has obtained an order from its tribal court demanding that a child born in Ohio who has resided in Ohio his entire life with an Ohio foster family, whose parents, his mother has now died, but his father lives in Ohio, has ordered that the child be sent to live on a reservation in Arizona with a family he's never met. We participated in that case, went to the Ohio Court of Appeals, and the Ohio Court of Appeals said, you have no personal jurisdiction. The standard for personal jurisdiction is that a person must have some kind of relationship to the forum jurisdiction, right? Minimum contacts. You know, remember international shoe from law school, all that sort of stuff. The fact of this genetic connection cannot be sufficient for this kind of minimum contacts that's required. So far as I know, the CJ Jr. case is the first ICWA case to address the question of personal jurisdiction in that context, and it's a very important one. The bottom line with regard to these cases, and I often step back when talking about ICWA because a lot of time I think it's easy for our minds to think that what we're talking about is foreign children. It's easy to just assume, well, we're talking about kids who they're subject to a tribal government, so they're foreigners. They're not Americans, right? But that's absurd, of course. All Native Americans are citizens of the United States, and state governments owe an obligation to support their best interests, to protect their best interests, and to prioritize their best interests over the demands of third parties. We know from the Troxel versus Granville case that no state has constitutional authority to allow a third party to obstruct a parent's decision about the upbringing of their child. And what ICWA does is precisely that. It gives tribal governments authority over children who, in many cases, have never even visited reservations and may have no idea that they are eligible for tribal membership and have no cultural affiliation with a tribe. In fact, after some state courts tried to adopt a doctrine called the existing Indian family doctrine that would have said, well, we're going to apply ICWA only where there is a cultural affiliation to a tribe, tribal governments and their allies screamed holy hell about that, and now states, for the most part, don't apply that doctrine, meaning that ICWA is and only can be a race-based statute that violates the equal protection rights of American citizens.
Thank you, Tim. Professor Fletcher?
Hello. Good morning, good afternoon. I don't know what time it is. I'm East Coast. Matthew Fletcher from Michigan. I'm a citizen of the Grand Traverse Band of Ottawa and Chippewa Indians, and wrote a couple amicus briefs so far in the Brackeen case. That's sort of my connection to this case. I wanted to start off by noting that it's been a long time since I've been on a manel. That's what we call in academia, a panel that consists entirely of men. And I think that's a little odd. I want to always emphasize, I'm not trying to pick on Jeff or anybody who organized this. Sometimes these things happen, but
It was accidental. We did have,
we have no doubt.
several women who were supposed to be on the panel, but they canceled at the last minute. So
well, people
there
vote
is,
with their
there
feet.
is a
what can
reason
you say?
for it.
I do want to honor the people that inspire me and that I've worked with over the years, and people I grew up with. I mean, primarily are women and who work on the ground in Indian country and elsewhere to defend the rights of Indian children and Indian families and Indian tribes. And it's not people don't get rich doing ICWA. It's not very glorious. These are hard cases. There's no happy case in an ICWA case, and it's really about the vestiges of colonialism. So it's hard work, and I want to honor those people. So I'm going to start by just describing some things about the law, and we'll see where we go from there. I only have 15 minutes. Are we keeping time for me? Or am I just going to guess? Thank you. Okay, let's start with the sort of the baseline rule we have when we assess a statute like the Indian Child Welfare Act, and that does come from Morton versus Man. And the baseline rule is that when Congress passes a law that is rationally related to the fulfillment of the federal government's trust responsibility to Indian people and Indian tribes, the Supreme Court, the inquiry ends there. The Supreme Court will not assess the constitutionality of that law. The test is, it is a rational basis test. If Congress identifies an obligation that it possesses under its trust responsibility with Indian tribes, And the act that it chooses to undertake when it identifies that obligation, if that act is rationally related to the fulfillment of the trust responsibility, the inquiry ends there. We do spend a lot of time talking about footnote 24 in the Morton versus Man case, which is where the whole political status classification discussion comes from. But that's the primary baseline rule is, more accurately stated, so long as Congress is acting in fulfillment of its trust responsibility, the inquiry ends at that point. Now let's talk a little bit about the trust responsibility, and for those of you who don't know much about the history of federal Indian law, that'll help explain why the Supreme Court adopted such a rule. The trust responsibility is sort of an amorphous obligation on behalf of the United States that derives directly from the founding of the United States. The trust responsibility is truly constitutional. It used to be, way back in the day, when the United States was first entering into treaties with Indian tribes, that Indian tribes agreed to come under the protection of the United States government. Now, that is a doctrine of international customary law where a smaller, one might say, politically less powerful sovereign agrees to come under the protection of a larger, more powerful sovereign. And that's what Indian tribes did in those early treaties. And in really all the treaties, all 400 or so treaties, almost all of them mention something about this notion of protection. Now that morphed fairly quickly and unfortunately into a metaphor of guardianship, where Congress occasionally, but primarily the executive branch, people on the ground who worked for the federal government, and the Supreme Court started describing the duty of protection as a guardian-ward relationship. This was a fundamentally racist description, describing Indian people as children, as wards, as completely legally incompetent to handle their own affairs. That's not what the duty of protection was intended to be. Internally, tribes retained all of the powers of a sovereign that any nation would possess. External sovereignty is what tribes gave up when they entered into this protectorate, so to speak. Now, in the more modern era, in the last half century or more, the United States has more accurately described this relationship as a trust relationship, akin to a trusteeship where the United States serves as a trust, as a trustee, and the tribes serve as sort of a beneficiary. There are separate trusts that are not at play here where the United States holds assets in trust for Indian tribes. But what we're talking about sometimes is called the general trust responsibility, the general trust obligation. And it is, as Justice Gorsuch recently described, the treaty relationship between Indian tribes and the United States. Indian tribes gave up an enormous amount to the benefit of the United States. And the United States, in exchange for very specific things in some treaties, but more generally, undertook the duty of protection, an obligation to ensure that tribal sovereignty may continue to exist and to protect Indian tribes and Indian people. That's the duty of protection and the trust responsibility. The history, as those of you know even a little bit about Indian law, is that the United States has almost always failed in its trust obligations. So it is deeply ironic that one of the few times the United States made a reasonable effort, a rational effort to fulfill its trust obligations, the other side refers to the statute as racist. How ironic. I want to point out a couple of provisions in the United States Constitution in which I guess you could say are racist. The reference, for example, to Indians not taxed is a thing that existed in the original document of the Constitution, suggesting that for purposes of proportional representation in elections, the United States would not count for purposes of a state's population, Indians not taxed. And that text was deleted from the original Constitution, but now sits in the 14th Amendment. Nobody knows what an Indian's not taxed is. Congress is the one who decides what those Indians were or are. And it is a provision in the Constitution that describes Indians. As the other side says, this is possibly based on ancestry, based on race. A professor here close by at Stanford, Greg Lebowski, did legal history paper on that and suggested that the word Indians really just meant at the founding, we know one when we see one. Now, the weird thing about this Indians not taxed thing, you would think, well, that's just fundamentally inappropriate. Congress has defined in several statutes, many of which are still in play, the Indian Reorganization Act, yes, the Indian Child Welfare Act, the Major Crimes Act, numerous times where the United States has said this statute applies to Indians and has allowed for the courts, perhaps federal agencies, to make clear determination on exactly what Indians means for purposes of that particular statute. But so long as Congress is acting in furtherance of its trust responsibility, then that is all that matters, so long as there is a rational relationship. A couple of comments on the equal protection argument. I just wanted to highlight that there are references in the statute that I think are really important for purposes of the discussion today, particularly the reference to best interests of the child. Every time a child is removed from an Indian custodian, placed in the care of the state, perhaps a foster placement, rather emergency or voluntary placement, and ICWA is invoked so that the child might have to come back to the Indian family, to the Indian custodian, whomever it might be, or an Indian family, other tribal members, whomever. The state court is obligated to undergo a best interest of the child determination. That's repeated in the statute again and again. There are, so under state law, the best interest of the child determination is sort of a keystone for about half of the states. ICWA requires that in every state when it comes to an Indian child. Frankly, every state should adopt a best interest of the child determination for purposes of all sorts of decisions. In fact, pretty much every hearing, in my opinion, in state court should have some element where the parties in the court engage in a best interest of the child determination. I want to point out a few things about state courts at this point. One of the reasons that tribes are so interested in getting their children out of the state foster program, out of state court hearings in busy jurisdictions often take no more than a few minutes. Very rarely, nobody cares what the kids think. Nobody cares what the biological parents think. These state court determinations and state agencies are woefully underfunded. At least 22 states are under class action lawsuits, many of which are effectively under receivership in federal courts because their child welfare system is irrevocably broken. The state of Texas, where the Brackeen case originated, a few days, in fact, after the Brackeen case came down, the Fifth Circuit allowed a class action lawsuit to proceed against the state of Texas. One of the allegations against the state of Texas is that if you are in foster care as a child in Texas, it is almost guaranteed that you will face some sort of physical and or sexual assault. And when we talk about best interests of the child and we compare whether or not an Indian child should be in a state court system like that or in a tribal court system, those kinds of factors should be at play in a determination by the state court. ICWA absolutely requires that. Every state, frankly, should require that. And I guess I'll conclude. I don't know how much time I have.
You still have some time, 5 minutes?
Oh, do I? Okay. Well, let's see, what else can I talk about? Actually, I don't know. I think I'll probably just, I'll move to, what do they call that? And reserve my time. No, I was going to give it to Keith. I delegate my time to Mr. Ambassador Harper at some point. Well, in any event, but thanks for the opportunity to talk, and I'm interested in the questions you might have later on. Thank you.
Thank you, Professor Fletcher. Rob?
Thanks. And this obviously does present lots of sensitive issues, and in many cases it feels like the parties, sort of are talking past each other, where, both the plaintiffs and the defendants, at least in this instance, and I think in most instances, purport to want to advance the best interest of the child. There's no party out here that is looking to, sort of advance some side interest. It really is focused on the best interest of the child. My first contact with ICWA, what sort of, was the first time I'd ever even heard of the statute, was in 2013 when there was a case cited in these briefs that came before the court called Adoptive Couple v. Baby Girl. And the facts of that case are probably about as extreme, as you're going to find in ICWA land, but as our case, the Brackeen demonstrates, they're not entirely unheard of. And what that case sort of teed up for me was sort of the constitutional problems sort of underlying the statute. And what had happened in that case is you had a non-Indian mother of Hispanic descent in Oklahoma, unmarried, had a child with a man who was a member of the Cherokee Nation. He was not on the reservation. He was in the military, and I think shortly after she conceived, he ended up getting deployed. And he relinquished his parental rights to her via text message. Not the most romantic way to do that, but that's how he did it. So she knew very early that she was not going to have the father's support. She realized also very quickly that she was not in a great position to raise the child, so she immediately looked for an adoptive family to take her child. She found one. It was a family in North Carolina that had difficulty conceiving and was looking for a child. They didn't realize at the time that ICWA was going to be involved, but they essentially made contact with the mother. She vetted them, and the family then supported her all the way through the pregnancy and was there at the delivery and took custody of the child immediately back to North Carolina. As it turned out, the father was a tribal member. He realized what had happened, figured, hey, that wasn't the part of the deal. I was hoping that you would just stay in Oklahoma and then I could visit the child. I just didn't want to have anything to do with finances and all that sort of stuff. The tribe ended up getting involved, and the Cherokee tribe tried to get the child basically back from the adoptive couple who had now formed attachments and bonds with this child who had never been at any moment of her life in the custody of a tribal member, had never, as far as we know, set foot or stroller on a tribal reservation, and was now a part of a family that had loved her and embraced her. So that was the situation in which sort of I first encountered ICWA, and the statute was very complex. And if you read the kind of dueling court opinions in there, there's not even a clear sort of 5-vote majority for the reasoning. You can tell Justice Thomas joined the opinion, but had sort of a separate reason for getting there. And so that was sort of my introduction to ICWA. And what I've learned in that case is that, like many things in the 70s, the intentions were good. The enactment maybe was slightly less clean than it should have been. You read the section 1901 of the code, which Congress is setting out its reasons for the statute, and you'll hear some of the things that Professor Fletcher was talking about. There were clear abuses going on that Congress heard testimony about. If you read the legislative history, there are many heart-wrenching stories in the legislative history and the testimony about state child welfare agencies effectively seizing Indian children from Indian families, and for reasons largely based on cultural ignorance. Seeing a child that's being raised by more of an extended family, free-range parenting perhaps, maybe they're ahead of their time, so that's becoming in vogue now, and essentially saying, oh, this is bad for the kids, or the parents are impoverished, this is bad for the kids, and taking the kids away from the family and then sending them to live with non-Indian families. One can certainly appreciate Congress, sort of focused on stopping that type of abuse. But what we have seen in our case here in Brackeen and an adoptive couple is that the statute sweeps far more broadly than that. So in the case that we are litigating, we represent 3 clients, the Brackeens, the Cliffords, and the Librettis. And just, the case is called the Brackeens. Their situation is interesting, right? They, basically were foster parents of a child, ALM. Both of the biological parents supported placement with them, but the Navajo tribe, the mother was a member of the Navajo tribe intervened to try to block the placement and put baby ALM with a non-family or a non-relative family, just another Navajo family. So you can debate whether sociologically it is better for ALM, this child, to grow up in a family that they've known, the child has known since essentially infancy, a family that loves the child, has devoted itself to the child, but is culturally different than the child's biological family, or whether it's better to take that child and put her in a Navajo family, so that it can be raised by sort of in a setting where the culture of her family or her biological family is consistent with the one she's raised. That is a sociological question. I'm not prepared to answer that. I don't know. I suspect you could have positive and negative outcomes in both situations. What interests me about that is trying to figure out where Congress gets the authority to tell a state court how to process the adoption proceeding of a child who has never been in the custody of a tribal member, who is not living on a tribal reservation, and essentially can tell the state court, which has authority, which has jurisdiction over residents within its borders, and has an obligation to care for the welfare of the child, where Congress gets that authority. And in the statute, Congress tells you where it thinks it gets the authority. In section 1901(1), it says, recognizing the special relationship between the United States and the Indian tribes and their members, and the federal responsibility to Indian people, this is what Professor Fletcher was talking about, Congress finds, number 1, that Clause 3, Section 8, Article 1 of the United States Constitution provides that Congress shall have power to regulate commerce with Indian tribes. And through this and other constitutional authority, Congress has plenary authority over Indian affairs. So Congress doesn't cite any other constitutional authority. It just sort of waves its hands and says other constitutional authority. The only statutory provision that is cited is the Indian Commerce Clause, which, as it says, gives Congress the authority to regulate commerce with the Indian tribes. So the Supreme Court has been very fuzzy about what that means, and there is language in various Supreme Court cases, the Lara case most significantly, where the court basically says, well, Congress has plenary authority over Indian affairs. And on one hand, if what Congress means by, or what the court means by Indian affairs is tribal matters involving tribal government, tribal land, then that is probably a correct statement of the law. If on the other hand it means plenary authority to regulate all aspects of Indian persons wherever they may live, that is a lot more difficult to justify under the Indian Commerce Clause. So what we pointed out, for example, is that if that is true, what that means is that Congress theoretically could essentially supersede all state law whenever an Indian person is involved. So it could change property ownership rights for Indian persons in California or in Oregon or Texas. Theoretically could change the burden of proof in a state court proceeding when there's an Indian defendant. Change the testimonial requirements for an Indian defendant. And our position is that the Indian Commerce Clause is a very, very slender reed to hang that sort of congressional authority on. And while there is undoubtedly a trust relationship between Congress and the tribes, and specifically with the land that Congress holds, the federal government holds in trust for the Indian tribes that live there, to extend that to say that Congress can regulate all social aspects of individual Indian persons is improper. Now this is, I don't think, is probably an issue the Fifth Circuit is going to feel comfortable reaching out to decide, because it is somewhat novel. There is not any precedent so far saying this. And in the adoptive couple case, the court kind of dodged this issue. But I think it is going to be an issue that will be teed up for the Supreme Court. Ambassador Harper and I probably agree. Whatever happens in the Fifth Circuit, someone's probably going to file a cert petition. The court's likelihood of granting it will depend on who wins in the Fifth Circuit. But either way, there will be a request, I think, to the Supreme Court. So that's an issue that the court could decide. And if the case goes up, we will certainly present it to the court. So secondarily, there's another issue that both we raised on behalf of our clients and the states of Texas and Louisiana, and I'm forgetting who the other plaintiff is here. There are 3 states who were plaintiffs in the case, and one of the arguments they raised, and we raised also, but they pressed it more aggressively, is that ICWA essentially commandeers state agencies and also state courts unconstitutionally, because it doesn't set up a separate federal adoption proceedings. You don't go to a federal court to have your ICWA case decided. You're still in state court. You don't have federal child custody officers. You have state child custody officers or state child welfare officers. And ICWA tells them what they are supposed to do in terms of finding the tribal connection, searching out families in which to place them. And so it provides direction to federal agencies. Again, this is an issue that's going to be difficult for the Fifth Circuit to decide, this sort of commandeering. There's only really been 3 Supreme Court cases that have ever addressed it. But it's also, I think, going to be an issue the Supreme Court will be interested in, because federalism sort of concerns have become more and more, I think, pressured to the court. Like it's something the court now looks at much harder than it did in the 70s or the 80s or even the 90s. So there's some serious federalism sort of undercurrents in here, even setting aside all the equal protection issues, just with respect to the federal government's authority over these state welfare proceedings, where you don't actually have, a child who's tribal member often, or in tribal custody. And so I think there's a chance that, Congress or the court will end up being able to sever parts of ICWA that exceed its powers and those that don't. And one of the interesting things to watch will be, what ground the court decides the case on if it ends up taking the case. Does it decide it on equal protection grounds? Does it sort of say, well, we don't want to get into equal protection, we want to avoid that whole tangle, and so we'll decide it on these narrower federalism grounds. So I think it has the potential to be a very interesting case, just in terms of federalism, and perhaps making some new sort of constitutional doctrine. We'll save time for questions, so I'll throw it over to Ambassador Harper.
Thank you. Yeah, absolutely.
Jeff, sorry to kick you out from
Nope.
the podium. It's just a little easier. Good afternoon, everybody. Thanks for joining on this important panel, and thanks to my co-panelists for their remarks. I'm going to divide my remarks into two sections. As Jeff mentioned in the introduction, we represent 4 tribes who intervened in the Burkina matter: the Cherokee Nation, Quinault Indian Nation, Oneida Nation, and Morongo Band. And essentially, to ensure the protection of the Indian Child Welfare Act because of its critical importance to these tribes, and as we saw with the amicus brief from 300 other tribes, importance across Indian country. So as mentioned, there are basically 3 areas where, well, the challenge was based on 5 separate constitutional bases: equal protection, 10th Amendment, this anti-commandeering doctrine, the non-delegation doctrine, the lack of power by Congress to enact ICWA, and substantive due process. In essence, the court below rejected substantive due process with respect to Congress's power, basically said Congress doesn't have a power to enact an otherwise unconstitutional law, so it did not go so far as the plaintiffs has desired to say that Congress, a la Justices Clarence Thomas's perspective, has a very narrow power when it comes to Indian affairs that has to deal only with commerce. Now, I'm going to just take a moment on that issue. I wasn't going to talk about it, but since it's been raised, let me say the law is absolutely crystal clear on this. The Lara case in particular stands for the proposition that Congress's power is plenary. That is the term used. And plenary means it is without bound, in essence, so long as Congress has exercised its judgment consistent with its trust responsibility and not in violation of other principles. And so in this instance, it does not have to be commerce. And it just has to be about Indian affairs, tribes and its members. In the Lara case in particular, it provided for the expansion of recognized criminal jurisdiction over non-Indians committing violent crimes, even though the Supreme Court had already held in the Oliphant case that tribes did not have that jurisdiction. That's how expansive congressional power is in this area. And so the notion that somehow the Supreme Court is going to reverse 100 years of precedent on the notion that the power is plenary in nature, I think is a bridge too far. So I'll talk a little bit about the Burkina case and the ins and outs of that, but I want to spend the majority of my time on the question of whether or not the Indian Child Welfare Act is sound policy. There are 2 competing narratives, one rooted in an ideological view that sees ICWA as discriminatory and disadvantageous to Indian children. The second view is that ICWA is sound and essential set of rules to protect Indian children, Indian families, and their communities. I will show that the former view is demonstrably incorrect and rooted in both ignorance or something more nefarious, and further, how the latter, from a perspective of what achieves best outcomes for kids is demonstrably the correct view. In October 2017, 3 sets of individuals led by a couple named the Burkines, along with the state of Texas and 2 other states, Indiana and Louisiana, brought a case in federal district court in Fort Wayne, Texas. Now, this court was selected as the court that is generally chosen for challenging ultra-conservative, pursuing ultra-conservative views of federal law. This would be this is the reason that particular court was selected. On October 2018, the district court struck ICWA down as unconstitutional on 3 separate grounds. We appealed to the Fifth Circuit. In addition, we asked that the ruling be stayed. The Fifth Circuit agreed to stay it, and that's important for 2 reasons. First, that in the interim, Indian children will not suffer the consequences of having to be stuck in an unconstitutional family court setting, as in Texas, as the professor had mentioned earlier. But secondly, it indicates that the Fifth Circuit thought that the defendants would ultimately prevail on the merits, as it is one of the factors that one weighs in granting such a stay. So I do want to talk a little bit about the amicus briefs that were filed, because I think one of the things to look at in this instance is who is on which side of the V. On one side, you have National Congress of American Indian, the largest and oldest tribal organization, and more than 300 Indian tribes. So essentially, and I've never heard a tribal leader speak ill of ICWA. I've only heard them support ICWA because they understand its implications to Indian children. But not only tribes, 21 states, including 5 states led by Republican governors and attorneys general. The Casey Foundation, as well as dozens of other child welfare experts, filed a brief that explained in detail why the Indian Child Welfare Act is so important and leads to optimum outcomes. Let me talk a little bit again about the Burkine holding. The most important issue, as I think everybody concedes, is the equal protection issue. Of course, as also stated, you cannot go too far up an equal protection analysis road without running into Morton v. Moncarey. Because Morton holds that the preference is not directed towards a quote-unquote racial group consisting of Indians. Instead, it applies only to members of federally recognized tribes. This operates to exclude many individuals, this is a quote, who are racially to be classified as Indians. Now, Mr. Sandefur from the Goldwater Institute talks about, well, this is a racial distinction because it's all about descent. It's not all about descent. Let me give you 2 scenarios. Let's suppose you have a mother who is a quarter native, and the requirement of that particular tribe is that her children, to be eligible, have to be at least a quarter native. Her child would not be an Indian child under the Indian Child Welfare Act unless they're married to another Indian, right? Because their child would be 1/8 Indian. Now, that same mother, if what the eligibility requirements was 1/8 Indian, then in that tribe, then that child would be eligible for membership. So you have it's not about the descent, it's not about the lineage, it's about the tie of that child to the specific polity. An Indian child is either a citizen or member of a tribe, or a child who is a child of a citizen or member, but also is eligible. Those are the 2 ties that qualify you under the Indian Child Welfare Act. The district court in the case relies instead on a case called Rice v. Cayetano. And Rice says that in certain instances, ancestry is a proxy for race. And the specific instance in Rice was a voting scheme under state law in Hawaii that allowed certain descendants of Native Hawaiians to vote, but nobody else. And basically, the court said in that case, then you have a racial distinction. But of course, that's not the case when it comes to Indian tribes. Every year, multiple Indian tribes allow only their members to vote, and their members typically are racially Indian, but only their members. Even if you live on the reservation, you cannot vote in most of those elections. And in fact, in Rice itself, the Supreme Court points this out and says that, you know, in the context of Indian tribes, this would be a non-issue. And so the notion that Rice can somehow have the force to apply in a case where you do have a polity, unlike in Rice when you do not have a polity, and where you have a political relationship, is again quite a slender reed to rely to strike down a 40-year-old statute. The way the court distinguishes Moncarry is by saying that Moncarry essentially should not apply with respect to things not on or near a reservation, which is an absurd reading of Moncarry. I mean, Moncarry had to do with an Indian preference policy that applies in the Bureau of Indian Affairs at the Department of Interior. Now, where does that apply? That applies in other places, Washington, D.C. There's no tribes in Washington, D.C. There's no tribes on or near the Interior Department building in Washington, D.C. That same policy applies in Tennessee. There is a Nashville Eastern Area office in Tennessee. That policy applies there. There's no tribes in Tennessee itself. So the idea that there's an on or near requirement is not supported by the law. It's not even supported by Morton v. Moncarry. You cannot read Morton v. Moncarry that way. It's simply not permissible under its own facts. Furthermore, in the Fifth Circuit itself, there is the Peyote Way, Church of Peyote Way case, which is about the ability for members of the Native American Church, who must be a quarter Indian and members of a federally recognized tribe, to use and harvest peyote. Well, you harvest peyote far, far from the reservation in the desert. So how could that be allowable if the on or near requirement, as the other side would like to insist on, was a requirement? Furthermore, there was a mention, but I think it's worth some discussion. The district court in this case neglected to do what's called a severability analysis. Let us suppose that, for purposes here, that there is some constitutional issue with the definition of Indian child. What was required under any constitutional analysis is that, especially here where there is a severability clause in the Indian Child Welfare Act, is that you should look at that definition of the Indian child and ask, can we carve out that provision which is unconstitutional? Now, again, let me repeat that I don't think it's unconstitutional, because I think that there is a direct tie when a child is eligible for membership and has a parent who is a member. I'm just going to take a moment on the two others because I want to get to the policy discussion. With respect to the delegation of legislative authority, the section that is attacked by the plaintiffs is section 1915C. This allows a tribe to change the priorities of how placements work depending on that specific tribe. And let me tell you why that's so important. If you're an Indian tribe, if you're, say, a Cherokee Nation child, it may make a lot of sense to not only make your child eligible to go to a family first that is of the Cherokee Nation, but also the UKB, which is a related tribe, both having capitals in Tahlequah, Oklahoma. And so this allows for the ability to adjust based on the specific circumstances of each tribe. And this kind of flexibility is essential when we're dealing with child welfare. And furthermore, this is not a delegation of responsibility at all. Powers, as the Lahr case makes clear, tribes have inherent authority. And so what this recognizes is that tribes exercising their inherent authority over their own children can make adjustments on the order of placement. And even if it were a delegation, of course, the Maserati case from the Supreme Court also says that tribes have the power, that Congress has the power to delegate authority to Indian tribes. A quick thing on anti-commandeering. As Mr. Dunn had noted, this was essentially an argument that the district court held that even though the commandeering was of state courts, that the anti-commandeering doctrine applied in that circumstance. ICWA, this is a quote from the district court opinion. ICWA offends the structure of the Constitution by overstepping the division of federal and state authority over Indian affairs, commandeering states to impose federal standards. And then he says this case primarily involves state courts rather than legislative bodies or executive officers. And just because it does so does not mean there is no violation of anti-commandeering, but that is plainly wrong. In the New York case, which is one of the seminal cases for anti-commandeering, quote, federal statutes enforceable in state courts do, in a sense, direct state judges to enforce them. But this sort of federal direction of state judges is mandated by the text of the Supremacy Clause. So again, that forecloses the possibility that ordering a state can be an anti-commandeering violation. But let's really focus in on the real most important issue, and that is ICWA sound policy? And the pro-ICWA perspective starts with this. Prior to ICWA, 25 to 35% of Indian children were snatched from their families and their communities. That's in the congressional record. Now, I live in Maryland. I look at and I think, what would happen to our community if a third of the kids, take any 3 kids, take your kids' 2 best friends, and one of them is taken away from their family? What does it do to that community? What does it do to that family? What does it do to that child and the many, many children taken in that way? And this is after generations of Indian tribes having their children snatched from them through boarding schools and all kinds of other means. And so the Indian Child Welfare Act was passed to stop that from happening. And here's the thing. I suggest that everybody who is interested in this matter go read the Casey Foundation brief. And that brief was written by child welfare agencies, including NE Casey Foundation, Adopts America Networks, American Adoption Congress, Center for Study of Social Policy, Children and Families Futures, Children's Defense Fund, Child Welfare League of America, the National Alliance of Children's Trust and Prevention Funds, and just on and on and on. So these agencies, what are they focused on? Are they ideologically driven? Are they libertarian? No. They're focused on what is best for kids. That's all they focus on. And what they say is that ICWA is essential. It's not a left or right issue. It's not about Christians or non-Christians. It's not about blue or red. It's about what's best for kids. In the words of these experts, quote, the values inherent in the Indian Child Welfare Act are the gold standard of child welfare for all children and families, not only children who meet ICWA's definition of an Indian child. They go on. Casey Family Programs, for example, structures social welfare practices for all of the children and families that it serves in the 9 nationwide field offices according to the core principles of the Indian Child Welfare Act. It also says ICWA standards of context-specific application of universal best practices in child welfare supported by decades of experience and research that children are best served by preserving as many connections with the birth family and community as can be done safely. I could read from, there's all kinds of passages that this brief is excellent on. I'll finish with this one. Striking ICWA down not only would be wrong legally, but would have devastating real-world effects. Undoing careful work of Congress has done to enact ICWA standards, which are grounded in the best practices for all children would cause enormous harm to Indian children and undermine the ability of child welfare agencies and courts to serve them. Finally, ICWA's successful outcome across the range of proceedings that it covers reflects the congruence between ICWA's principles and child welfare practices. So this is based on social science. What is best for kids? This is based on experience of those. You know, you can have your anecdotes, as they seem to like over at the Goldwater Institute. You can have your anecdotes. I got a bunch of other anecdotes when Indian children are put in bad non-Indian families. We can have dueling anecdotes, or we can listen to those who know what they're talking about and have evaluated this and have backed it with social science. And who's on the other side? On the other side is ideologically driven groups. And let me say one thing for some of the, if you're some younger lawyers in this thing. If you want to look, always question a ideologically driven argument, because they start with their ideology and then they go find the facts that fit that argument. And that's what's going on here. You know, we have a situation where they don't like things in which there's distinctions made between groups of people, even if there is good reason for it and even if it's settled constitutional law. The notion by the Goldwater Institute, for example, is that ICWA discriminates against Indian children, which I find a little rich coming from the Goldwater Institute. That they're saying, you know, they're not exactly have a lot of credibility on issues regarding race. After all, they're named after Barry Goldwater, right? Barry Goldwater said of Brown v. Board of Education, it was a federal overreach, an abuse of power. The case that struck down segregation was an abuse of power, according to Barry Goldwater. And that's their ideological deity. He voted against the breathtakingly important Civil Rights Act of 1964. Think about that for a minute. And what they'll say in defense is that, no, it wasn't really about race, it was about states' rights. And I would just say, well, there's a lot of Southern governors that articulated that same message. And in fact, I'll rely on the assessment of Barry Goldwater from Martin Luther King Jr., who said, while not himself a racist, Mr. Goldwater articulates a philosophy which gives aid and comfort to the racist. That is the ideological bent from which our opposition is coming from. So I don't know what's in the hearts of those challenging the Indian Child Welfare Act. But what I do know is it would have devastating consequences in Indian country. And it would undermine a law that has provided far greater security for Indian children than what occurred prior to its existence. Thank you.
Thank you very much, Keith, and everyone else. Since Keith went last, maybe I'll give you guys, Tim and Rob, if you want a 1-minute rebuttal opportunity, then I'll field any questions.
As I said, ICWA is a complicated statute, and there's a lot of issues going on, and so I encourage you to look into the materials that cover these things in much more depth. I just, very briefly, with regard to some of the fallacies that were uttered by the other side, including the childish juvenile swipe at Barry Goldwater, this is the first time that I've heard this brought up, because usually it's the other way around. Usually people are saying, Barry Goldwater voted for ICWA, which is true. So which way is it? Is Barry Goldwater forever tainted because of the vote against the Civil Rights Act, which he later said that he did view that did believe it was constitutional after the Supreme Court said it was? If so, then that taints ICWA. On the other hand, if everything Goldwater did was right because he voted for ICWA, then how do you bring up these things? So that doesn't really work. The essential fallacy, really, with regard to the argument against the equal protection thing, is the idea that if a statute excludes people from the racial category, it can't be a racial category, right? The argument is, like in Menkari and things, well, this can't be a racial category because many people who would otherwise fit within the racial category are excluded. That's fallacious. We know because, for instance, if a statute applied to only left-handed black people, that would still be a racial category, even though right-handed black people would be excluded from that statute, right? The question is whether the category is defined by race and for a racial purpose, which ICWA plainly is. It applies to Indians as generically defined. It applies to children based on their biological ancestry alone, not based on any cultural or linguistic or religious affiliation of that sort. So, to give a good example, under ICWA, William Holland Thomas, who served as chief of the Cherokee tribe in the 19th century, he would not have qualified as an Indian child if he were alive today under ICWA solely because he happened to be racially white, even though he spoke Cherokee, lived with the Cherokee, served as a chief of the tribe. Sam Houston, who was an adopted Cherokee, spoke Cherokee, served as Cherokee ambassador, would not qualify as an Indian child under the Indian Child Welfare Act if he were alive today. The fictional character Linda Wishcob in the book The Round House by Louise Erdrich would not qualify as an Indian child under the Indian Child Welfare Act, even though she lives on reservation, speaks a tribal language, identifies and practices traditional cultural practices and so forth. So it's a fallacy to say that a racial category is no longer racial if it excludes some. Second fallacy is this term plenary often gets thrown around. We know it cannot literally be true that Congress's authority in this realm is plenary. True plenary authority means absolute power, and Congress simply doesn't have absolute power. True plenary authority is a state of war. That's what true plenary authority is. If the Congress really has truly plenary authority, could it ban Native Americans from getting divorces? Could it ban them from leaving their tribes? Could it prohibit them from leaving tribal reservations? Could it deprive them of freedom of speech or force them to join a church? There was a time where the answers to those questions was probably yes. It certainly cannot be yes after the passage of the Indian Citizenship Act that makes all Indian citizens of the United States, and not to mention the Indian Civil Rights Act. Finally, just one other point is I do agree very strongly with Professor Fletcher when he says that the best interests of the child should be the consideration that we keep our eyes on at every stage of these proceedings. The problem is that the devil's in the details there, right? Texas state courts have said that there are two separate best interest standards. California courts have said the same thing in the Alexandria P case, the famous Lexie case 3 years ago. There are two separate best interest inquiries. There's a best interest inquiry for white children, black children, Asian, Hispanic children, and then there's a separate Indian best interest standard. In fact, Texas courts have called this best interest standard a racist construct. They have said that the best interest test is a, quote, an Anglo construct that should not be foisted upon children who are racially defined as Indian under ICWA. So, secondly, very often you'll hear courts say that the best interests under ICWA is a one-size-fits-all, Congress has determined this is always the best interest standard that's written into ICWA. Now, if there's one thing that the history of
Tim,
Indian law
I'll give you
should teach us,
just a few
and I'll wrap
more
up
seconds
with
here.
these sentences. If there's one thing that the history should teach us, it's that Congress should not be in the position of saying X is in the best interests of all children who are defined by us as Indian, right? What should be the consideration in best interest is an individual child's best interest in that child's individual circumstance. And it's because ICWA doesn't do that it falls short of the constitutional standard.
Okay, thanks. Let me see if anybody has any questions at this point. Yes, please. I don't know if there's a mic or...
I can speak loudly.
Okay, speak loudly, please.
You can hear me.
I'll stand right in here. I'm from Los Angeles County, and I am in the dependency court. I represent children who are dependents, and we have a hybrid system. And I am in the dedicated ICWA courtroom. And the question, kind of the statement, is to all of you, but specifically to you, Mr. Sandefur and Mr. Dunn, is do you think this is potentially social engineering when you would apply the thinking that you're promoting that it's okay for a child to be taken from an Indian family and placed with I'll just use a white family, it doesn't matter, whatever the nationality is, other than their own cultural, tribal connection. Because the idea in keeping children together, be it black children, Hispanic children, but specifically Indian children, is so that they have that cultural connection, and it gets diluted. They don't know who they are as they get older, and those ties are broken. So would you consider it social engineering when you try to apply all of this and move kids from where they might be, in your example, in a foster home, back to, move them from their tribe, their parent, either way?
Well, let's try to get down to actual cases, because we talk a lot of time in these big abstractions. So let's talk about actual cases, which the other side always dismisses as anecdotes. These are reported cases that set binding precedent, but the other side calls them anecdotes. But let's talk about a case called Renteria, for example. In Renteria, the parents were killed in a car accident here in Northern California. The father was a member of the Miwok tribe out in Shingle Springs. And there were two families that wanted to take the three orphaned children in. And one of them was tribal, one of them was non-tribal. And here you have a situation where you have no state agency breaking up any Indian family. You have no private agency breaking up an Indian family. You have no social engineering going on. And yet the tribal court invoked its authority to take the children away from the non-tribal family and place them with the tribal family. Now that order was later voided for violations of due process, and the case went to trial in state trial court. And yet the state trial court said, this is an ICWA case, therefore the children should go with the tribal family. I'm happy to say that case ended in settlement. Now, is there social engineering going on there? Is there social engineering going on in the JPC case, the Tohono O'odham case that I cited, where an Indian mother wants to sever the parental rights of an abusive ex-spouse so that her child can be adopted by her new husband? That doesn't seem like social engineering to me. Now, there can be no question whatsoever, that ICWA was passed in reaction to a conscious effort by state and federal agencies to try and take these children off reservation land and place them with white families because that was considered, the better thing to do for social engineering reasons. No question whatsoever. And I don't think any of us have ever denied that ICWA was passed with good intentions. The problem, as I said, is the devil's in the details, especially when you're talking about kids who are not living on tribal land, have never visited tribal land, live in ordinary suburbs. These are like the Lexi case. Here's a child who, just like every other child in her classroom in Southern California, but because her great-great-great-great-great-grandfather was Choctaw, wholly separate set of laws apply to her. She doesn't speak Choctaw, never visited Choctaw lands, right? Is that social engineering? You could, if there's social engineering going on, it's on the other side in that case.
Don't you think a child has a right to know who they are and where they come from? Because if you don't allow that child to find that out, then you have cut them off completely. And that really can kind of be a social engineering, because they know nothing about their whole other heritage, nothing. And ultimately, we have determined that children want to know who they are, where they come from. Even if they're adopted by someone else, they're going to go back to find their family, their heritage, and their roots. Yep. And so if you can give that to a child through ICWA and the active efforts and all the things that like in California, clearly we have a state statute that mirrors federal, it's even higher than that. Right. Then why not do that?
So that's a very complicated question that could take us all day to debate, but I will give you the very simple answer, which is those considerations are part of a proper best interest standard. And my view is that the proper standard should be a best interest standard that takes those considerations into account, but also balances them against other things such as the safety of the child, the child's particular circumstances, individual needs, and so forth.
Let me give an opportunity for
let me just say a quick word about that. I do think that if you don't have ICWA, it will be social engineering by states, and because that's what existed prior to ICWA, and there's no reason to say we wouldn't go back to the status quo ante. You know, Sandefur talks about issues of anecdotes. But the way ICWA normally applies in the vast majority of cases is that Indian children end up in healthy Indian families. My youngest child is an ICWA kid. We have 3 biological children, and we decided to adopt a child. We notified both my wife's tribe, the Caddo tribe, and my tribe. And there was a baby girl that was born in San Jose, California, while we live in Washington, D.C. at the time. But for ICWA, that child would have ended up in a non-Indian family and had no idea about their culture, their language, anything. Instead, within a few months, she did a naming ceremony in my wife's tribe, in a teepee, an all-night ceremony. And she has regular contact with her tribe and other Indian families and other Native people. So she's never going to have those questions about whether I belong, which many, many adoptees do, and even when they come from loving families. And so those are the anecdotes that occur over and over and over in Indian country, and that is why universally it's supported by tribes. And the only reason I bring up Mr. Barry Goldwater is not in any kind of slur, but to just say, you got to know who's giving your message. And when your message is coming from a place that is named after a guy that voted against the Civil Rights Act and called Brown v. Better Education wrongly decided, you got to question their perspective, that's all. Because I just don't happen to think that Brown was wrongly decided. I don't think you should have voted against the Civil Rights Act of 1964. And those are just considerations that should be brought when your side sees that as the North Star of their ideology. That's all.
Professor Fletcher, you had a comment, and then there was one other question in the audience, and we'll go to that, and we might run out of time after that. Go ahead, Professor Fletcher.
I'll try to use it all. All right, so I'm so glad that somebody who's a practitioner in the trenches and all this is here, and I think that's really important. And I wish there were people up here who had represented, bio parents, adoptive parents, children themselves. Those are really important perspectives. And one of the things that I guess you could say anecdotally, and I think there's data to support it, is how difficult it is. How much, just straight out racism and sexism there is in the child welfare system. I mean, we all have anecdotes about this as well. I mean, you have situations where bio parents in a negligence type situation have lost their kids for emergency purposes, temporary purposes, and those things kind of extend on. Foster parents, so easy for them to start being pretty judgy about those bio parents. And being judgy in front of the foster kid, right? It's not that hard with a younger, impressionable child to turn that child against their biological parents. I've seen it happen. I see it happen in my own children's school district, where there are, Native kids who have been adopted by non-Native families, and the non-Native families, they're friends of mine. They are just vicious when they talk about the bio parents, and I don't think they realize how much of an impact that has. And that is just day to day. It's the foster families, the adoptive families, the placements. It's so easy to just draw upon a long history of Indian hating and being being judgmental about people who were poor. And I think that, more generally, and I think that is a really important analysis that we need to take into consideration. There's a lot of data behind that. I also want to talk about the anecdotes about Native kids who are adopted out into loving non-Indian families. Their outcomes are not great, often. And this was true if you read in the legislative history of the Indian Child Welfare Act. You saw a lot of Native kids being adopted out into non-Native communities, higher rates of drug addiction, alcohol addiction, depression, even suicides. All of that data is there. And now you're starting to see, and just in the last 10, 20 years, more and more, primarily anecdotal, but more and more data from kids who are people of color, adopted out into white communities who struggled really hard. I grew up in an area where in southwest Michigan where, 10% of the area was, and the kids in the school that I went to were people of color, primarily Native, but there were a few African American students, a few Asian American students, and it was rough. They really struggled. And sometimes these are okay, perfectly acceptable circumstances. That's why we do the best interests of the child determination. And, it does matter that the other side primarily relies on anecdotes. Speaking of fallacies, I love watching that show, The Good Place. They talk a lot about philosophy and logical fallacies in that show. There's something called the straw man fallacy. And I've been listening to the straw man fallacy all day, all these pretty entertaining anecdotes, like what happens if you would apply a statute to only left-handed people of color, for example. That's a straw man fallacy. The response to that is just to say, remember what the baseline rule is. So long as the government is behaving in a rational manner, a reasonable manner towards fulfilling its trust obligations, then that fits the bill. Every single provision in the Indian Child Welfare Act is tied to the rational basis, is tied to the trust responsibility in a rational way. For example, the beyond a reasonable doubt standard, that Congress took evidence and made a determination in the testimony leading up to the Indian Child Welfare Act that states were making it way too easy to terminate parental rights of Native people. Many Native people were not allowed to testify in their own defense. They didn't have the right to counsel. I thought it was pretty sad that Mr. Dunn mentioned the text messages from the bio dad in the adoptive couple case. They changed Oklahoma state law so that if you're going to have a biological parent actually has to appear before a judge, which is actually what ICWA requires. But in Oklahoma, after that case, they changed state law so that would never happen again. That you can't, a bio parent can't lose their parental rights via text message. I think that's critically important stuff. Thanks.
Thank you. So we have 1 minute for one question. Go ahead.
Keith and Matt, thank you for your clarity of purpose and being very clear on what the issue is here. Genocide doesn't happen always immediately. Sometimes it takes hundreds of years to accomplish that purpose. And it's important, I think, in this discussion to remember that all these measuring sticks, all these standards that are put out there are not created by a tribal culture. They are created by a white government that does not want to acknowledge and has never acknowledged the equality of the tribal nations that saved them and gave them the opportunity to even exist today. Racism is not what tribes are based on. This racial classification ignores the constitutional acknowledgement that tribes are nations. We are not some racial classification, and we did give up some ideas and rights with promises that have been broken millions and millions of times. But you don't have to look any further to the failure of your argument than to look at the reconciliation efforts in Maine. There's a great documentary just finished up called Dunn, and all these Native children, even after the passage of ICWA, were continued to be removed from houses by the DCF up there, Children and Family Services, without notification, without any, and in one part of the film, one of the workers actually says, I don't care whether or not they learn to dance as long as they have sneakers on their feet. The perspective is one of respecting tribal culture and the protection of it. And I'm sorry, but in my opinion, the federal government, the European settlers have slowly tried to find a way to deal with the Indian problem through termination, extermination, reorganization, allotments, in every manner possible, making us do blood quantum when that's not something that was ever required in our tribal history, and say, well, you're only a tribal member if you have 20% of our blood. That is not a construct of tribal culture. It's one of the non-Indian society that we're forced to deal with. And the only good thing they've done is to acknowledge it in 1978 with ICWA and make an effort to protect that culture, which has to survive, and stop the genocide they've tried to do for hundreds of years. So respectfully, I think Matthew's 100% correct. If there's a rational basis, it's done. And there was more than a rational basis to establish it. I don't see how you overcome that argument when you go to the next level.
While obviously we're going to disagree, I do want to respond to 2 points. One is I totally agree with you about the federal mandate on blood quantum, that it's obviously absurd, racist, and infringes on tribal sovereignty. And then the second point is, just to clarify, neither I nor anybody has suggested that tribal membership is racist. There's an important distinction that I perhaps should have made clearer, which is tribal membership versus Indian child status under ICWA. And the California Supreme Court has made this quite clear. Tribal membership is, of course, a matter of tribal law in which no other sovereign has any say. Tribes can decide membership rules however they want. But federal law creates this category of Indian child status. Now, it happens to be triggered in some respects by tribal membership, but it's a separate classification. And Indian child status under ICWA, because that's a creature of federal and state law, has to be consistent with constitutional standards such as equal protection. So that's what we've been talking about here.
Okay, I will bring this to a close. Thank you all very much. Thank you to all of the panelists for participating in this discussion. Really appreciate it. Give them a hand. It's a difficult discussion, and I think the panel was well balanced about it, and great questions from the audience. Thank you.